My name's Mark Hefner. I'm the landowner advisor for the family of companies for the Braun and Gresham side and also for Plateau Land and Wildlife Management. And I'll be moderating today. So Chris and I will be working together. Owning rural land in Texas can be complex and can come with a range of issues. My landowner role or landowner advisor role is to help you work through those issues and get some assistance for you or provide advice. So that's something we can help with on a regular basis. Braun and Gresham is uniquely skilled to handle those unique problems in Texas when it comes to landowners' issues. Everything from rural real estate to eminent domain, conservation strategies, dealing with disputes as well. So we're going to work on that today. Our sister company, Plateau Land and Wildlife Management, works with filings for wildlife management valuation, ag valuation as well, and also have a team of expert biologists to help you on your property. Today, our guest of honor is Chris Bell. He is an attorney and counselor, and he'll be giving the presentation. Chris and I work together amongst the family of companies to help the wide variety of issues that I've mentioned earlier. So today is going to be, again, a unique situation where you guys can interact with us. We're actually going to unmute you, and you're going to have access to Chris directly or to me to ask questions. So anytime during the presentation, feel free to, as Chris pauses, feel free to interject a question. Again, you can actually speak directly to your computer. You also are going to have the option, as you always do, with the Q&A. It's kind of at the bottom of your screen typically, or it's something that very specifically says Q&A. You can type in your messages to us. I'll be monitoring those and getting them to Chris as well. So either way works for us. One thing I want to make you aware of that we are going to be recording this video or this presentation. So it kind of goes back to if you to the answer or asking your questions. If you have some confidential issues or you have some things that you'd rather not put in front of a group, then you're going to get our contact information. Chris and I are actually going to reach out to you later and just connect with you via email. So we're going to have an opportunity to address all your issues, whatever they may be, but don't feel the pressure to do it today. Like I said, the recording will be available going forward. Last thing is, I said that was the recording, so I think we're good there. Without further ado, I'd like to get Chris introduced here. And Chris, again, Avalon and I are here to help, but you are the star of the show going forward. So Chris, please take it away.
Thank you so much, Mark, and thank all of you for joining us this afternoon. Today's program, as you see up there on your screen, is titled Creative Ways to Deal with Neighbor Disputes. And some of you are probably going to listen to some of this and say, well, that's not all that creative. That just sounds like common sense. Well, some would argue that in this day and age that, and my slides aren't moving. So Avalon, you might have to move them.
Hold on 1 second, Chris.
No.
Oops.
Well, they were moving a moment ago.
Technology.
Now let me see. Nope.
I'm going to request control, Chris. Oops.
There we go.
And then
Nope. Won't move. Can,
yeah, Avalon will probably.
okay, thank you. So there's an old saying that good fences make good neighbors, and that saying is so old and has been used in so many different languages and in so many different cultures. Nobody even knows where it came from. And I have to admit that when I first heard that phrase, good fences make good neighbors, I was very confused, because those of us who grew up in the 60s and 70s watching television, whether it was the Honeymooners or the Flintstones or Mary Tyler Moore or I Love Lucy, on almost any of the popular programs, neighbors were the best of friends. But then you get out in the real world and find that oftentimes neighbors can become the most bitter enemies. Um, and the things that I've heard and actually witnessed since I've been practicing law, and I've been practicing for almost 29 years now, and joined Braun and Gresham last fall in the litigation department here. But during that time, the things that I have heard that have taken place between neighbors, some are absolutely mind blowing. And I'm reminded of a story. Years ago, there was a lawyer officing with us, and an older couple, rather conservative looking couple, came in to visit him, and they were complaining about the dog next door that barked incessantly. And they asked the lawyer, they paid him a small retainer, and they asked him to write a demand letter to their neighbors saying that something had to be done about the dog and asking them to get in touch with him. And a few days after sending that letter, he got a letter back from the individuals he had sent the demand letter to saying that no action would be required because someone had fed a steak laced with poison to the dog, and the dog had been killed. And we could never prove it, but it seemed pretty clear that that couple had come in to just provide some cover so that they could act like they were trying to handle the matter in a civil fashion, when all along what they planned to do was kill the dog. And the story still almost makes me sick to my stomach every time I tell it, but I share it with you here today just to really illustrate how things can get so badly out of control between neighbors. And this webinar is designed to offer some suggestions on how to deal, how to confront and deal with some of those disputes, and what to possibly do if a dispute rises with a neighbor. And you can say good fences make good neighbors, but if we can change the screen, you could also say that proximity breeds contempt. The dog next door keeps barking. The neighbor's animals keep coming on to my property. The tree on my neighbor's property is growing a limb that keeps coming further and further over my property. It's going to fall on someone. The neighbors drive across my property in order to get to theirs. The parents that own the property next door let their kids come down for the weekend, and they stay up all night playing loud music, and we can't sleep. And since we live in a very litigious society, a lot of people would be confronted with those situations and immediately think, I need to call a lawyer. Well, I would tell you that that's the worst thing that you could possibly do. Because what happens when lawyers get involved, it completely changes the dynamic. Yes, you have put your neighbor on notice that you have a dispute and that you want something done about it. But you've really also broken off any chance to easily settle the dispute. Every very good chance that the other side will lawyer up. You and your neighbor are no longer going to speak, and it's just going to escalate from there. And I want to go over and confront a neighbor about any of those things? Hell no. It is awkward, and it's very uncomfortable to deal with those types of matters. But I want to share another old saying with you, and this one is very popular and used a lot by Braun, the well-known Texas psychologist, and it's choose discomfort over resentment. And what that really means, and with what we're talking about, is to not be afraid to engage, because the more the dog barks, the longer the tree limb grows, the more the neighbors drive across your property, the more resentful and angry you're going to become. So address it. And I know that that's a lot easier said than done, but in those 29 years of being licensed to practice law here in the state of Texas, I've seen way too many lawsuits that could have been avoided with some upfront communication. So pick up the phone and ask if you can come over and talk to your neighbor. And you might find out that your neighbor has no idea about the problem, has no idea that they were causing you any pain and discomfort whatsoever. And obviously, if you don't know about something, you're not going to be in a position to fix it. And it would be a lot better to hear about the situation from your neighbor than by getting a letter from a strange lawyer making some demand. And a lot of people in those circumstances would say, well, why didn't they just come over and talk to me? And you might be very surprised and find someone that you have as a neighbor that, you know, really wants to work with you to take care of whatever the problem is. And like I say, that's not terribly creative, but in this day and age, maybe with the way things have gotten, it is somewhat creative. It's still not too late in today's society to pick up the phone and try to communicate one-on-one or two-on-two and work something out. And I'll tell you, there's always the possibility that you try that and your neighbors are assholes and they don't want to work with you at all because they're incapable of wrongdoing and they just don't have any desire to work anything out. So now what do you do? Well, what you don't do is you don't take matters into your own hands. You pick up a saw and go over and saw off your neighbor's tree limb. Now you're the wrongdoer. Now you're trespassing and doing something to their property. And so what you're going to mostly see, what we're going to talk about today are two of the areas that come up most routinely between neighbors, and that's trespass and nuisance. And we're going to start with talking about trespass and what is trespass. Well, you own the land in question, and the elements that you would have to consider would be your neighbor entered your property and it was physical and it was intentional and it was voluntary and it was unauthorized. You never gave your neighbor permission to do whatever it is, and it caused injury to your right of possession. And that last element gets a little difficult because are you physically injured by what they're doing? No, you're injured by virtue of the fact that you own your property. And if somebody trespasses and enters your property illegally, then you have a cause of action just by this, because you've lost the exclusive use of your property. They're gaining some benefit, they're taking advantage of your property, and therefore they've engaged in trespassing. And let's use the example of the neighbors who keep driving across your property. That's a pretty straightforward trespass. And because it's obviously physical, it's intentional, it's voluntary and unauthorized. And just by doing that, it caused injury to your right of possession. And when it comes to trespass, that's about as clear cut as it can get. And in that type of situation, where someone's accessing your property or using your property to access their property, whether you're trying to work it out person to person with your neighbor, or whether it winds up in litigation, obviously what's going to be the most logical way to settle that matter is to enter into an easement agreement. And I say that because Then it's in writing. Then it can be filed down in the county property records, and then it goes along with the property. And it makes the most sense because let's say you and your neighbor work it out, and he says he'll pay you, and you all have a handshake, and he'll pay you so much so that they can drive across your property. Well, that handshake isn't going to be recorded at the county courthouse, and someday the property will probably change hands. And since the handshake hasn't been recorded, suddenly the new owners of the property don't want someone driving across, and you say, well, Joe, who used to own the property, said it was fine and we worked it out, and they say sorry. So it just makes a lot of sense in this day and age to have everything buttoned up, enter into an agreement and an easement, define what can be used, and work out a price for that. And you'll be doing away with a lot of problems down the road as well. But sometimes when you're talking about trespass, it's not as clear cut. What if there's a plant next to your property, a manufacturing plant, and they're storing a lot of plastic in there, and a lot of plastic particles are moving off the property, floating onto yours, or blowing onto yours? Well, when we say that trespass has to be physical, that of course includes human beings, individuals coming onto your property. But if it also means that if I cause someone or something to invade your property, or don't remove something from your property after being put on notice of what I've done, then that's also trespass. And I actually have that case right now. A woman who bought about 7 or 8 acres and was raising 3 horses on her property. And there was a plant next door, and plastic particles kept blowing onto her property. And she learned from her veterinarian that if the horses were to ingest the plastic, it could cause them very serious health problems, or perhaps even kill them. So she was forced to move the horses off the property, and it's raised a very interesting question regarding damages, because when she comes to want to resell that property, she's going to have to disclose the fact that there's plastic on it. And a lot of people who were to buy 7 or 8 acres are going to want to have horses or some type of wildlife on the property. So it's definitely going to affect the resale value. And we believe that that needs to be taken into consideration by the court. So, and interestingly, she tried to talk to the owners of the plant, and they came over and they tried to clean up her property. But meanwhile, they weren't doing anything to stop the plastics from coming out of the plant and moving over to her property. And finally, she's had enough. She's very upset. She feels like it's ruined this little paradise that she had for herself. So now we're in court. And we're going to move on to nuisance, unless anyone has a question. Trespass. Yes.
Hey, it's Mark. I do have a question. My family owns 126 acres in rural Mason County, so not near anything, and it's a recreational ranch. What were to happen, or what should I do? What steps should I take if my family shows up out there for a weekend of hunting or recreation, and lo and behold, there's people walking around on it, digging for rocks or whatever it is, with very obvious trespassing because we're fenced? What should a person like me do in that situation?
Well, first of all, as you see on the sign there on the slide, I would strongly advise putting up a sign like that on your property to make it very clear to people that it is private property and there's to be no hunting or no trespassing whatsoever. Do you have to have the sign? No, it's your property, and if somebody comes on it without permission or authorization, they are trespassing. And when I say, don't be afraid to engage. I would give you that same advice, but I would be careful how you engage, especially if you're going to talk to a group of hunters. They have guns, and that changes the equation somewhat. Some would say, well, you should get a gun too. I would advise against that, because that could cause the situation to immediately escalate. But a lot of times in those situations, if a landowner does confront who's ever on the property, they're hoping that nobody shows up, and they're hoping that the owners don't show up. And once an owner does show up and approaches and says, you really need to get off my property, and I would try to do that in as calm a fashion as you can, even though you're going to be probably a little upset that someone has come on to your property. But in most instances, they would probably leave. And if they don't, I would recommend calling the authorities, because it's criminal trespass at that point. So that would be my suggestion.
Okay. Thanks, Chris. Appreciate it.
Absolutely. And if anyone else has questions, we're going to have time at the end of the program, and feel free to jump in. But we're going to move on to nuisance, and that can be a little confusing, because trespass and nuisance are so similar. But what our state Supreme Court has said is that nuisance involves an interference with your use and enjoyment of your land, and trespass involves interference with your exclusive permission. Trespass doesn't have anything to do with your enjoyment of the land, whereas nuisance does. And for the elements of nuisance, let's say you're trying to figure out if your neighbor is causing a nuisance, and if you look at the screen, your neighbor entered your property. Was it physical? Was it intentional? Was it voluntary? No, well, I'm on trespass still. I'm sorry. Enjoyment of your land. And so some of the same factors you would see in trespass, but like noise can be a nuisance. No one has come onto your land, but the noise is so great, it's causing a nuisance, and it can be actionable. Let's talk about the kids whose parents let them use the property next door on the weekends. I mentioned that earlier. They're not coming on your property, but they're loud as hell, and they stay up all night. And is that a nuisance? It certainly could be. Did the noise substantially interfere with your use and enjoyment of the property and cause you unreasonable discomfort and annoyance? Well, that's the question that a jury or judge is going to have to deal with. Did the neighbors create or maintain the condition intentionally, negligently, or by abnormal, dangerous conduct? And did you suffer injury or damages? Well, in that particular case, when we're talking about the kids on the weekend property, most people agree that folks have a right to sleep comfortably in their own homes. And if you're being awakened at all hours of the night because of the noise coming from next door, obviously sleep is not going to happen. And your neighbors that own the property aren't there and aren't making the noise, and they certainly didn't tell the kids to go to the weekend property and raise havoc. But a jury or judge could certainly find that it was negligent for those parents, the owners of the property and your neighbors. It was negligent on their part to allow a bunch of kids to come down without any supervision, because it was reasonably foreseeable that they would raise havoc, and they would be up all night, and they would create that kind of noise and that kind of nuisance for their neighbors. And so they could certainly be found liable for creating a nuisance. And I want to share a situation that will really kind of take us back to where we started, because nobody likes bitching to someone or about their kids. And most parents really don't like to listen to complaints about their children. That's, I just think, the way that most of us are wired. So is it going to be uncomfortable to have that conversation? But you need to say something. And I would venture to guess that 99% of the time, once parents hear about a situation like that, they would be willing to do something. But I actually had a friend who had a lake property, and he knew his neighbor. He didn't know him well, but he knew him. They were both from Houston. And my buddy and his wife had just had a little baby, and they would go to the lake property, and they wanted to get some sleep. And of course, they were going to bed early because they had this little baby. And the folks next door were just letting their kids come down and use their lake house, and they would be up all night playing music and loud voices. And it was really creating a lot of problems and keeping them from sleeping. And so since he knew his neighbor, he sent him an email and told him what was going on, and he expected to get a rapid response and have it taken care of. Instead, he didn't hear a peep. So I wish it had a happier ending. It actually wound up and had to be taken to the justice of the peace, and an order handed down that they were going to have to lower the volume on the property when the kids came to town. Shouldn't have never gotten that far, but sometimes there's no other avenue to proceed down. So these are some of the situations, and if while I've been talking, if you thought of other situations you'd like for me to talk about, but also, be mindful. We've talked about your right to enjoy your property and your exclusive possession of your property. But when you're a landowner, obviously all kinds of disputes can occur. And
hey, Chris.
Yes.
You can leave that slide up. I had another situation I wanted to run past you, even a little more personal. My mother and father retired to Lake LBJ years ago, and used to be full of a community of all either people that lived on the lake or people that owned houses and lived somewhere else, and they would come in and visit. So it was always, the owners. Now, as the times have changed, a lot of those units, a lot of those homes, specifically her neighbor, it's gone to a rental service. So we all know their names, their variety of rental agencies out there that are renting homes out all over the country. And what happened in the beginning was just a very rowdy situation, similar to what you described, but now they're renters. So these renters that are coming in are partying all night, keeping my mother and father awake with no recourse because they're the renters, they don't care. In that situation, what does the affected landowner, what kind of recourse do they have? And you may have some similar recommendations for going to the rental company. But again, I'm thinking about instances where the opposing party or the offending party is not the owner of the property. Can you address that, a little bit?
Yeah, and I appreciate you bringing it up because it's very timely in this day and age, because a lot of people are taking advantage of some of those rental services like Airbnb and VRBO. And if the owner is not absolved from responsibility just because they're renting their property, they have some duty, just like the owners of apartment complexes. There's a reason that they do background checks. Now, I'm not proposing that you're going to do a full background check on everyone who leases your property, but you do need to take steps to try to keep those situations from evolving. And what you will find that a lot of people who are renting out their properties now, and I would certainly advise this if any of our audience members fall into this category, or if you are renting out your property, you should have some rules and guidelines there when you list it, and say that there will be no parties or no entertainment and whatever else you want to insist upon, so that you've laid down the law, and that the people renting your property and Also, if you don't have that in there, that's certainly going to suggest to whomever is renting your property that there are no holds barred and you can do whatever you damn well please. But if it continues, if it's just one weekend and things get out of hand, would I suggest, trying to stir it up with the owner of the property next door? No. But if it's, continual, weekend after weekend or day after day, just depending, and it's clear that this is going to be an ongoing situation, I would strongly encourage you, if you don't know the owner of the property, to find out who it is. And almost all appraisal records are online now, and so it's pretty easy to identify owners and run them down and talk to them and tell them that we've got to do something about this, and you've got to be checking more closely about who you're renting your property to. And then if they refuse to, and they can certainly be liable because of the negligence they're showing in renting their property and creating a nuisance for you. So I think that's a situation that could come up more and more in this day and age, and people should really be mindful about it, because just like when you check into a hotel room, you can't do a whole lot of, start doing a whole lot of things that are going to disturb the people around you. And so if that's happening, the folks who live in that area close by that are being impacted about it certainly, have some recourse.
Great. Thanks, Chris.
Let me just, we're going to go back. I want to do more questions, but I also want to remind you that at Braun and Gresham, we say that we are advocates for you and your land, and we do love the land. And if you are facing condemnation, if you have an easement dispute or property line dispute, all those types of things, and obviously we also handle a whole host of transactional matters such as estate planning, etc. But really, what being advocates for you and your land means is that if you have a dispute, it doesn't have to be about the land for you to give us a call. Maybe a breach of contract. You bought 50 head of cattle. You were promised 50 healthy head of cattle. They arrive and 20 are sick and dying. That's a breach of contract. That's something we would be in a position to handle. It could be fraud. You're asked to get involved in an investment based on some promises that have been made, and you make the investment and you found out that these were all false promises, that they're very bad misrepresentations. That's fraud. You possibly have a cause of action. Personally, I've been, as I said earlier, licensed to practice for 29 years. Most of that time has been spent in litigation, and I've always had a general practice where I handle just about everything under the sun. And we have a wealth of experience at Braun and Gresham, and if you have a dispute that doesn't just fall along the guidelines of land law or property law, still feel free to give us a call. And in most cases, we'll probably be able to help you. And if we can't, I assure you that we will send you to someone or refer you to someone who can. So like I said, we're going to have questions, but before we go there, I want to remind you about Braun and Gresham's newsletter. We call it LAS, the Landowner Alert System, and it's a great way for landowners to stay informed about issues that might affect their property. And you can subscribe on the website down there, braungresham.com/contact us, /sign up there, receive the newsletter, and stay informed. I want to thank you for joining us. And also, like I said, I want to open it up for any questions that you might have.
Thank you, Chris. Just as a reminder as well, if anybody wants to actually ask a question, just go down to your bottom of your screen typically, and there'll be what looks to be a little speaker or a little microphone. You can unmute yourself. Feel free to ask. If you don't feel comfortable doing that, go to your Q&A and type in a question for Chris or myself, and we'll be happy to jump into there. So while we're wrapping that up, there is our contact information. You can reach out directly to Chris if you feel comfortable doing so. If you just want to speak to somebody that's not an attorney and just want to have a conversation before we go to that level, feel free to reach out to me, and we'll have a conversation. And then what I do is figure out who needs to be brought into your particular situation to address the issue. So that's something else to consider. We're also going, again, I think I said this early on, we're going to record this. We'll send you a very simple follow-up email, so you'll have the recording. It's a great thing to be able to share. If you have other folks that could use this message, you can always also refer back to that. So I'm going to pause right there just for a little bit to see if there's any questions that you'd like to ask.
Chris, can you hear me?
I can.
Oh, thank you. Appreciate this excellent session here. My question is about navigable waterways. Have one that goes through our property, and it seems that the definitions of navigable waterway are so inconsistent from county to county in the state of Texas that sometimes we don't know which way to turn. And we wondered what advice that you have for those who have a creek and maybe have a dam on a creek that might create that imaginary second, I guess they talk about second levels, side banks, make it legal. It's getting very complicated as this central Texas area gets crowded and people want rec access.
Well, thanks for the question, Glenn. And water law, as you probably know, and as you just stated, can be extraordinarily complicated, but it has been heavily legislated in the state of Texas as to what you can do with free-flowing streams and stuff. And a lot of it comes down to diverting the water. And if a neighbor were to come in and divert the path of water to where it was now coming onto your property and causing problems on your property, in that type of scenario, you would certainly have a cause of action to look at, because you can't divert the stream in that fashion. And then there are all other types of laws and pertaining to surface water. And everything is designed so that your neighbor can't develop their land in such a way that water is just flowing onto your property and causing damage or flooding. But if those are the types of situations you're looking at, then definitely you have something that should be explored. And there again, I think, if it's something where, your neighbors clearly added something to their property that is causing that type of situation, I would try to have a talk with them to see if we could do anything about it, because those aren't simple cases. They can be rather complicated and expensive, and it would make, I think, sense for both property owners to see if there's something they can come up with and agree upon mutually.
Trespass and access to the property, is there a good way to handle something like that? In other words, people, they see a stream and they assume they can walk 15 feet up either bank and argue about it.
Well, I said good fences make good neighbors. Good signs can sometimes make good neighbors too. And I think that if you don't want people, I can see that, easily happening. And if you don't want people coming up onto your your bank, I think you should make it quite clear that they're not welcome there, because I think in those circumstances, a lot of people would assume, well, I'm on this little waterway, so sure, I can just go up here and rest for a while. Well, that could actually get out of hand after a while. So you should probably mark it and make it clear that trespassing isn't allowed.
Thank you.
Thanks, Glenn. And Glenn, if Chris and I we'll kind of reconvene and kick this around. We may have somebody inside the firm with a little more knowledge of the navigable waterways. I've heard multiple stories about that and visited a client up in Williamson County that was encountering the exact same issue that you're referring to. Kayakers going up and down his property. The navigable waterway is fine. Where his problem was exactly like yours, where people would stop the kayaks, get out, they'd actually start fires along his bank to camp overnight. So let me dig into that with Chris a little bit and see if there's maybe something a little more information we can provide. I know there's been some challenges in as far as the navigable waterways go.
Well, and if it's a situation where they're camping too, I think I would suggest buying some tarantulas and putting them out there on the banks to make it really an unwelcoming place for campers. But it becomes a very difficult situation because, and probably if it's happening like that, you would want to call the criminal authorities, because obviously there's criminal trespass, and it would be very hard to go down and identify all the people who are trespassing upon your property. So if that's the situation, it's probably gone from the civil level to the criminal level, and you might want to just call whoever the criminal authorities are in the area.
Good, thanks, Chris. We do have one question that was entered with the chat. And Chris, you're gonna have to listen to this. I'm not sure if I completely understand it. I think I have an idea. How do you handle a land perimeter clearing for fencing and shared wildlife fence installation, along with any future repairs? So I guess somebody's clearing their property along the fence line, and they're going to install a wildlife fence. I'm assuming they're talking about one of the big ones, and along with any future repairs. That may be because they're working together. I'm not sure.
Where the neighbors are working together? Because did you say joint installation?
Well, I'm not sure. How do you handle land perimeter clearing for fencing and shared wildlife fence installation? So yeah, that to me means they're going to share that fence line. And then along with any future repairs, maybe they're talking about after once installed, how do they work together to maintain it?
There again, that kind of goes back to what we were talking about with easements earlier. That's great that the neighbors are working together to put it in, but as far as what the responsibilities are for the respective owners, I would have all of that in writing, and it wouldn't necessarily be filed with the court or with the property records. But if they have an agreement between themselves that's in writing, and they can certainly structure it in some way that the agreement would stay with the property, even if it was resold, to avoid a problem in the future with different owners. But I would definitely have it in writing and not just do it as a handshake deal. Most of the business for lawyers, if we're talking about land or commercial litigation, you name it, usually it comes from handshake deals. People are trusting someone, everyone's excited, there are never going to be any problems. Then the business deal goes south, or something does happen on the property, and suddenly all you have is this handshake. Everyone's memory of what was agreed upon is different, and it winds up in litigation. So it just makes so much sense to, you know, write it up, what you've agreed on, have folks sign it, put it in a safe keeping place, and it'll avoid a lot of controversy in the future.
Great. I'm gonna ask that particular attendee if that was, if that answered their questions. If not, you can send us another one to clarify, or again, you can reach out to us independently and provide more details. It's up to you. So I think that pretty much answered that question as to what you would recommend when they're working jointly or working together. So we're going to go with that one. All right. I think that is all. Does anybody else, before we sign off, have any more questions? You can, like I said, you can unmute yourself and just ask it, or you can type it in. Okay, I believe that's it. Again, thank you guys for being on here with us and hanging in there. And Chris, thank you, of course, for your expertise. Please don't hesitate to reach out to us. You'll receive a follow-up, and feel free to provide oh, hang on. We got one more question just popped up before we jump off, but thank you guys. Is it worth getting neighbor participation and financial in fence clearing, installation, and future repair, or better just to do it yourself? So maybe that's the clarifying question, Chris. Is it better if you're going to do a fence clearing and project? Is it better, in your opinion, to do it all on your own, or try to get the participation of your neighbors?
To some degree, I guess that's a personal choice, because obviously there's also going to be joint control if there's shared financial participation.
Okay.
But I think the good part of that, knowing that so many disputes that arise about fencing, I think it makes a lot of sense to try to work with your neighbor and share the installation cost, because then both sides are agreeing on the front end as to what they want and what they believe they need, and that could avoid a lot of conflict in the future. So if you have a neighbor who's willing to participate in that fashion, I would highly recommend it. Just realize you're giving up some control, but you also might be avoiding any kind of dispute in the future.
Thank you. You know what? That actually brings up another situation that I had at our property in Mason County. This may help the client a bit, or the attendee a bit. One side of our property, about 3,000 feet, was in horrible disrepair. And so one thing I've done, I've got neighbors on three sides of me. I've connected with all of those folks. This is rural land, so we're not out there much when those folks are, but we've all connected. And so when it came time to do a fence repair, he and I spoke about it, and we did financially split that. So it was 3,000 square feet, or 3,000 linear feet. And it was a very hefty bill. So we split it. And then that, of course, is a great financial break. But as Chris alluded to, we all knew where the property line was. We all knew where the fence was going to be. We knew there's going to be some clearing involved. So it benefited us there as well. We now had some road and some access that we could do. And we discussed how it was going to look, because in certain portions of the property, they had to push the debris, trees, brush to one side or the other. And so by us working together, we talked to the contractor, and he almost split it. He pushed that debris around so it wasn't all on one property. So I can say from that example, working together typically does make it a little more friendly. I've heard of cases where somebody's griping or complaining about, my neighbor just went in and bulldozed the entire fence line and put up new fences, and now I've got all this mess. But at least if you're having communication, you understand what's coming, and the neighbor's going to feel like they have participation. I'm not a lawyer at all, so I don't know how nitty gritty to get with agreements and whatnot. That could be something for Chris to
But
help you with. Go ahead.
Mark, you brought up something that I think is very important, because obviously what comes up when you're talking about fencing is the property line. People going onto someone else's property when they're building their fence. And obviously, if you're doing it jointly, you're going to have that agreement up front. And and another really important reason to have everything in writing, so that everyone will know that that was the property line that was agreed upon, in case it comes up in a future survey or something that you were off. At least you have the writing to show that there was no trespass, because everybody agreed up front that that was going to be the line where the fence should be installed. And also, just thinking about it, when the ownership changes of the property, that's why it's so important to have it in writing, because there could be confusion and some people starting to think, oh, well, that's my fence. Oh, well, no, that's my fence. And so if it's documented that it's jointly owned by the two properties, it just will avoid that conflict going forward. And one other thing I want to point out, because I think this is very real life and it comes up, people realize these types of things for one reason or another. Like I said, a survey is done and they find out that a property line is off. And let's say you do talk it out with your neighbor, like I suggested, and you come to an agreement. And then if you're like lawyers, you're going to procrastinate. And then you might procrastinate so long that you just forget about it. And then you get old, and then someone dies or someone moves and nothing has been documented. And I have heard of those situations. I've seen those situations. So once you have an agreement, and don't put it off, and go ahead and get it written up. Go to a lawyer if necessary, if you want to make sure you have the proper language. But certainly if it's something that needs to go in the property records, don't put it off indefinitely. Get it written up.
Okay. I think that took care of that. I'm going to ask the attendee again. If there's something that we missed, please don't hesitate to call or reach out via email. We do have one attendee with a hand up. I just want to make sure that we got to you. I believe we did. There you go. Thank you. You took it down. So I'm going to assume, unless we have some more questions, we'll pause again just briefly and allow you to jump in there. Send us a message on the Q&A or just speak out loud. I think my opinion of the questions is there's people that are staying on the call because they're listening to your questions. So never think that your question won't be valid, because we have folks that are attending that probably have some of the same questions, just haven't thought about it. So again, I think we're going to close it up pretty quick because we have no more hands and nobody's unmuting and the questions are answered. So again, guys, Chris, I'm going to let you wrap it up and then I'll just say my spiel. But thank you guys for participating and for your questions. Chris and I will send a follow-up email. You'll have all the information you could possibly need. Please don't hesitate to reach out to Chris or I, and we'll go from there. So thank you. And Chris, if you want to take us out.
Well, thanks so much, Mark, and thank you all for inviting me to come on this week. I hope people will continue to join the webinar series. I think we've put together a lot of interesting topics, trying to make it as helpful for landowners as possibly. And just like I said before, even if it's not about your land, if it's about your land, definitely call us. But if it's just about you, we're advocates for both you and your land, and chances are we can help you and would love to do so. Give me a call. I appreciate it. Thanks, Mark.
Thanks, Chris. We'll see you later. Thank you, everyone.